Welcome to criminal law here at McHenry County College. This is typically a first-year law school course, though some schools break it up into 2 semesters and call it both criminal law and criminal procedure. We cover it all this week. And maybe you have a little bit more time if you have a 16-week class with me. But your assignments this week will gravitate towards reading the chapter, taking the 10-point quiz, a very interesting discussion forum that we're going to conduct involving Drew Peterson. Remember how I told you that we always try to pick local cases? Well, the Drew Peterson case is a case of a police officer from Bolingbrook who had divorced his first 2 wives, and his 3rd wife was found dead in a dry bathtub. And interestingly enough, the coroner said she drowned. Well, her family challenged that, and they reopened the coroner's investigation, and they decided that with the strangle marks around her neck and a few other things besides no water in the bathtub, that she'd probably been murdered. So he was charged with murder, Mr. Peterson, the police officer, was. In the meantime, his 4th wife, Stacy Peterson, went missing. Because they didn't have initially either the 3rd or 4th wife to testify at trial, the prosecutor needed to use what is called hearsay. This is an out-of-court statement made by someone who's not present. However, if you remember from our first week study of the Constitution, there's a whole series in the first 10 amendments in the Bill of Rights that contain criminal law protections. And one of them is a right to a speedy trial. Another one is a right to confront your interrogator. And therefore, hearsay under the 6th Amendment is usually kept out of court, meaning there isn't either the 2 wives who have something bad to say about Mr. Peterson available to testify. The prosecutor, who had no friendly relationship with this particular police officer, parked him in jail, ran down to the legislature, and changed the hearsay law in Illinois into something called Drew's Law, which allows hearsay to be heard under exigent circumstances or where people who could have been interrogated are missing. It allows the statements of the 3rd and 4th wife that were made to pastors, counselors, divorce lawyers into court to convict Mr. Peterson while he's sitting in jail. We study this week ex post facto laws, double jeopardy, speedy trial, and also this 6th Amendment right to confront your someone who's testifying against you. But we do balance it out in terms of our legal ethics with the understanding that the statements to these people that needed to come into court were with that the 2 wives were fearful for their lives, and that they were scared that if something happened to either one of them, that this person would get away scot-free. And so those statements were allowed in by a change in the law while the accused was sitting in prison. And indeed, if you read the articles, the jurors who were impaneled said that without the hearsay evidence, they wouldn't have had enough to convict Mr. Peterson. The case has gone up on appeal, and Mr. Peterson's cases have been on trial or on appeal the entire time I've taught here at McHenry County College. So we have something about him every semester. But there's a 40-page opinion that came out in the fall, and this is what we discuss in this discussion forum about whether changing the hearsay laws balances the victim's right to be heard from the grave versus the accused person's right to get a fair trial in an effective manner. So that's our discussion forum for this week. Your written assignment is to locate a police blotter. And believe it or not, I say this every semester, please do not give me a police blotter in which your name is in it or anyone in your family. I like you to have one that it is unrelated to you, because I don't want that kind of information. What I want you to do, though, is find a police blotter, dig one out of the Northwest Herald, anywhere online, and be able to tell me the elements of the crime, the punishment, and any restitution or any additional information or facts about that particular crime, to show me that you do understand what we do to publicize information about criminals. This particular lecture is going to cover both a little bit procedural and a little bit of substantive law. But again, since this is legal environment of business at MCC,
we're not going to cover every crime. We're just going to cover some white-collar crimes. People say, well, what does that mean? What's a white-collar crime versus a blue-collar crime? And it's probably an old-fashioned term because I don't think we have people necessarily going to work wearing white collars or blue collars as much as it maybe stereotypically was in decades past. But we're talking about things that happen in the business world. And again, like I reminded you when we talked about torts last week, which is a cousin to crimes, there is a certain amount of intent present. And we call that, in this realm, mens rea, which is mental state. But you have to have the mental state to commit a crime, and you also have to have an act or omission along with it. Meaning you can't just think evil thoughts about someone and have it be a crime. You have to do something or forget to do something. What would some of these white-collar crimes that we're going to discuss this week, where could they be found? They're found in federal, state, and local statutes, like we discussed in week 1. And there's also substantive and procedural aspects to it. The difference between a procedural and a substantive analysis under criminal laws is procedural is basically going to tell you how fast something has to occur, and a substantive is going to be more content-based. So like our speedy trial, you might say to yourself, that amendment might be more procedural in nature, tell you how fast the person has to be tried. But again, we're going to get back to those. I want to make sure that to start out, you all know the distinction between a misdemeanor and a felony. Misdemeanor is the smaller, more petty offense, and the felony has a jail term of more than a year. And they also have sort of different levels of mens rea involved with them. So we'll be talking about the lesser crimes and the greater crimes. In the realm of crimes that I'm going to talk about this week, I'd like to start out with fraud. And we picked up on fraud a little bit in torts. This is criminal fraud. And so sometimes people say, can you be charged with both a tort and a crime at the same time? Yes, it could be a criminal action that you showed enough intent that you meant to commit a fraud. It could also be a tort. What kinds of fraud would you find in a criminal white-collar context? Mail, wire fraud, bank fraud, mortgage fraud, credit card fraud. So those may be a little more distinct when I put those 5 qualifiers in there with fraud than what we talked about when we talked about fraud and misrepresentation in the civil context last week. Of course you know that, and you'll know this just from the common use of the term, we have a crime called conspiracy. But in conspiracy, you can't conspire just with yourself. You have to have 2 people or more in a conspiracy. So Ocean's 11, Ocean's 12, Ocean's 13, those all have enough people in them to be conspiracies if you enjoy watching those movies. We also have money laundering. And money laundering is, as it suggests, oftentimes it involves overseas international bank accounts and monies that are being put one place instead of another. We have perjury. I'm sure all of you talk to your children about perjury, and those that have them, and we talk about perjury in the context of lying in court. So to perjure oneself is to lie in court. That is also a white-collar crime. We have a very interesting distinction, and I like to watch our newscasters about this. We have burglaries and we have robberies. Perhaps you didn't know the difference between the 2 of them. There are 2 differences. They involve where you were robbed and when you were robbed. Oh, I see that you have your hand up. Yes, that you are correct. In order to be robbed, you don't need to be in your dwelling. You can be robbed in downtown Chicago. You could be robbed here at McHenry County. But a burglary is typically at night and it's in your dwelling. And yes, there will be a quiz question on that one. In addition to the distinctions between burglary and robbery, we'll also be talking a lot about extortion, bribery, undue influence, bad checks, false claims. Students will say to me, I saw one of my bad checks up at that Nick's Pizza in Crystal Lake. Can they do that? And I'll say, yeah, they can. That's an exception to our defamation because if it's true and you pass them a bad check and it bounced, they can let people know in this jurisdiction that you've done that. If it's a false accusation, that's another story, and that's your defense as well. People can embezzle money from you. They can try to bribe you. People could try to give you money to get an A in a class. That's also a crime. if they're trying to bribe you. They can also extort money from you. They can say, they can call you up and say, I've kidnapped your child and I want $1 million. And if you don't give me $1 million, then I'm going to do this to your child. That's also kidnapping, but it could also be the act of asking you for the money is also extortion. Blackmail. If you tell on me, I'll tell on you for doing this. And again, this is a criminal level, not just, petty. This is very serious. People do pass $20 counterfeit bills in this jurisdiction, and you'll oftentimes hear a little notice that there's been a plethora of fake $20 bills being passed around in Crystal Lake, and yes, we do charge people with the crime of counterfeit. Students will say to me often, yeah, but that happened on the computer. Somebody, was extorting something and they sent me an email. And yes, the crimes that you commit on a computer are the same as if you were doing it with interaction between people. We have, they'll also have people say, can a corporation commit a crime? Yes, a corporation can commit a crime. We also have espionage and international crimes that we cover a little bit in this unit. Now, having said that, I've given you just a blush of what we have in terms of substantive content-based crimes. And again, you want to pick one of those when you're giving me your criminal blotter assignment. A student tendency when they just get online and they start putting in the Google words of white-collar crime blotter is y'all are going to come up with Bernie Madoff, Martha Stewart, Enron, and these massive cases that we do study here in Business Ethics 235. The difficulty in doing your 10-point memo assignment with this police blotter thing is those people have somewhere like 70 allegations or 70 indictments and then 73 convictions against them, or Rod Blagojevich had 14 indictments against him. I don't want you to try to do all of them. Just pick one and describe that crime in particular. There's also, as you guys are following, I'm sure, the Mueller investigation. There's obstruction of justice. There's collusion. There are other crimes that are out there, but these are the ones we focus on. And like I said, don't write me you only have to write a 3-paragraph memo. Please don't try to write up 73 violations. Having said that about the substantive side of crimes, I'd like to talk a little bit about procedural. Many of you are familiar with the Fourth Amendment, the Fifth Amendment, and the Sixth Amendment from our studies of the Constitution in the first week of class, and hopefully also from your studies of the Constitution before you came to MCC. Many people are very familiar with the Fifth Amendment because they've seen all sorts of criminals on television say, I plead the Fifth. My lawyer told me to plead the Fifth. That means you're not going to answer a question because you're afraid that you're going to incriminate yourself. We've just talked a little bit about the Sixth Amendment. We also have and we've talked about ex post facto, speedy trial, right to confront your accuser, right to have an attorney. Oh, that might sound like a famous criminal case that I am going to ask you about on your quiz, which is Miranda Rights. Many of you know that if you don't get read your Miranda Rights by a police officer or someone who's arresting you, that you then have the right to challenge that conviction. What are the Miranda Rights? Do you have to have that memorized for an exam in my class? Not memorized in order to recite them, though many of you probably can recite them from TV or movies, but you need to know that the Miranda Rights do provide sort of a warning that is given. It is a warning given when you're being arrested, that you have the right to remain silent, you have the right to an attorney, and if you cannot afford one will be provided for you. You may see those sort of formats in a multiple choice question. I'm not asking you to be able to stand up in class and recite that, but those are your Miranda Rights. Those are provided under a case called Miranda that came, I believe, out of the Ninth Circuit, and those were an interpretation of what the Constitution meant under the Fourth, Fifth, and Sixth Amendment. Students will ask me, in addition to the Miranda Rights, I got stopped. The police officer stopped me. There was a speeding trap outside of MCC when I was coming down 14. Could I refuse to stop? No. Can I refuse to allow the person to breathalyze me? No. Can I assert that the police officer cannot look in my car? This is kind of a little bit tricky, and we'll be fleshing out these cases more in depth in our exploration in this class. There is a right to search and seizure. but it has to be reasonable. One of the cases we'll be discussing will be the Wingspan Rule, which is if you're being stopped and they're checking you and they are breathalyzing you, or they smell drugs in your car, can they start opening your trunk? Can they start looking ripping apart with knives the seat of your car? We have the Wingspan Rule, and that gives you sort of a geographic idea of where it is reasonable for an officer to search in your car. It is not, they can open every single thing up. Can they ask you to get out and walk a line? Yes. And they certainly do. Having covered these basics, I do want you to know that that the criminal defense bar and the criminal prosecutors, which are different from plaintiffs and defendants in our civil matters, the prosecution, which are state hired and appointed lawyers, represents an amalgam of not only the state of Illinois, but also the deceased victim's rights and anyone else who might have been injured. And so they have sort of many hats on when they're bringing an indictment, which is a list of what you might have done wrong, to bear, where they list out multiple substantive crimes. And the defense bar is a group of lawyers that most of the time do pretty much exclusively criminal law. And that's because they know the case law that backs up all these amendments and the timing on them and the procedural and substantive rights that you may have under these cases. So if you have a criminal citation and you are arrested and you are summoned to court, you would definitely want to hire someone who's got criminal experience. The only other protection I can think about to sort of to provide you advice in this context is if you are arrested, you are allowed a phone call, and you are allowed to have a bond card to bail yourself out, and you are allowed to bond yourself out unless the crime is so heinous or there's so many of them that to do so wouldn't be in the state's best interest, or if they thought you were a flight or flee risk, meaning you will see criminals on television who are not allowed bond. But for the ones that I would think that most of McHenry County would have, and we don't have any, we don't have anything like what's going on in Parkland, Florida right now. Most of the time, depending on the nature of it, bond is something that you can use. There are also bondsmen. Bond means typically that you pay a percentage of what could be the overall fine for the crimes that you've committed. So you don't have to pay that whole $1 million that day. You have to come up with $100,000, or someone does, to have to get you out. And again, there's also an assessment of whether you're a flight or flee risk. Having covered all these, I encourage you to get started. Again, you don't have to memorize these crimes. You have to be familiar with them so that you can answer true and false or multiple choice questions about them. And a lot of them, like I said, you've heard about, you've read about, you read about them daily, and you have a lot of common sense to bring to light about these crimes. And get started on your Drew Peterson form, but remember, I'm hinting to you that in order to get a 10 on my assignment, you have to cover the procedural rights that belong both to Mr. Peterson and also that belong to the prosecutor. Mr. Peterson, while he was convicted and waiting for his appeal, sitting in jail, also was indicted and convicted of he tried to hire a hitman to kill the prosecutor who put him in jail, and he's been convicted of that. Please do not discuss that crime in this discussion forum. We're focusing on the trial of the death of the third wife. Do not discuss the fourth wife or the first or second wife at this point. We're just focusing on the hearsay issue that went up to the Illinois Supreme Court, and the Drew's Law was affirmed right before Christmas. And you will probably find that during the spring semester that a notice of appeal will probably be sent to the United States Supreme Court on this, because the attorneys definitely wish to pursue advancing Mr. Peterson's rights. Again, there's a 40-page opinion out there. You can get arguments for both sides for your discussion forum out of that 40-page opinion. Just make sure to cite to your authority if you're using someone else's work. And that concludes today's exercise on both criminal, substantive, and procedural rights. And hopefully you're drawing back on your first week's Constitution work and those amendments in order to carry out 3 wonderful assignments for me.